Here with us now is one of the hardest working women I know, plus trial attorney and legal analyst, Misty Marris. Misty, good morning. Thanks for waking up with us.
Good morning, Hannah.
You and I spoke yesterday. This is before we heard about this bombshell lawsuit, President Trump's Friday lawsuit against the Wall Street Journal, Rupert Murdoch, Dow Jones. For all intents and purposes, this is a very quick turnaround, I think less than 24 hours. What are Trump and his legal team claiming here that happened?
A very quick turnaround, Hannah, and also a very novel lawsuit because this might be the first sitting president to file a defamation lawsuit while being the president of the United States. I'm not aware of any other lawsuit that's come from a sitting president that sounds in a defamation claim. So the lawsuit says that this photo that was printed, this drawing, is false. And so the standard in any defamation or libel lawsuit is that the publisher acted with knowing disregard or knew that the photograph is false, that the picture was not done by Donald Trump, failed to verify it, and acted with what's called actual malice. That standard relates to any public figure. It's why defamation lawsuits are very difficult to prove when somebody is a public figure, because that standard is very stringent. It means that the publisher acted in a way where they wanted to harm the individual, where they published that false information. So that is the nature of the lawsuit. I will say President Trump, during his campaign, filed several defamation lawsuits, one against George Stephanopoulos and the network, and was successfully settled that lawsuit. So he's had a bit more success in defamation lawsuits than most public figures, but this one is certainly a novel lawsuit, given that it's from a sitting president.
Yeah, I remember that lawsuit with ABC, and I think it changed everything. So going back to this lawsuit, I mentioned some of the people who are being charged: the Wall Street Journal, Rupert Murdoch, the publisher Dow Jones, 2 reporters on the story. This is a lot of people. What is the likelihood that this case will actually go to trial?
So this type of case usually resolves before it ever gets to trial because it opens up a whole host of discovery, meaning information that comes during the course of the lawsuit that is to be exchanged between the parties. And a lot of that, Hannah, is communications that went on in the newsroom, the reporters. There are individuals that are identified here. Rupert Murdoch. I mean, think about that being an individual where the discovery obligations would include searching his phone and his emails and other electronic devices to see what communications were made regarding this article and the contents of it, this drawing and all of that. So that discovery process is very onerous, very deep, and requires a lot of information to be turned over. And that's why a lot of these cases ultimately resolve before it goes to trial. But when it comes to President Trump, he has not been skittish to push cases very, very far in the litigation process, where a lot of cases would fizzle out right from the very beginning, to the extent that this drawing is there's an allegation that it is false. It's not something that he did.
Right.
That's a question of facts. That means this case could live for quite some time.
Yeah, exactly right. President Trump says he doesn't draw, and that was not his language in the letter, and he is sticking to that. Our correspondent Raquel just reported the Trump administration late Friday asked a federal court to release the grand jury transcripts in this case, in the Jeffrey Epstein case. I was sitting here when this happened, and I remember there was a gasp with all the journalists in here. From a legal standpoint, how does the judge decide what gets released and what does not? What do you think we'll get to see?
So, Hannah, I would say don't hold your breath from the public who wants to know more about the Jeffrey Epstein case on 2 fronts. First, grand jury testimony, grand jury materials are secret. The default is that those are behind closed doors. It's a secret process. It's not released publicly. The standards are very different than every other standard when it comes to legal proceedings, where the default is about transparency and the public having the right to know about the court processes. That is different when it comes to grand jury proceedings. So whether or not the judge will release any of the information, any of the transcripts, is a huge question mark. There is no obligation to do so. And I read that filing, and it's based on the need for the public to know. And that's simply not one of the exceptions where, with respect to grand jury and opening that up for public view, it's just not one of them. It's usually only when the defendant wants to challenge the grand jury process or that material is needed for another case. The other piece of this is everybody needs to understand there are like 300 or 400 terabytes, and that's a huge amount for anybody who doesn't know technology. Okay, a huge amount of information that has been collected by the Department of Justice, investigators, prosecutors, that's in the possession of the Department of Justice at this moment relating to Jeffrey Epstein, that was collected in furtherance of what would have been a trial had he lived to see that day. It is a fraction of a fraction of a fraction of a fraction of that that's presented to the grand jury. So whatever, if something was to be released, I don't think it's going to be anything novel. I don't think it's going to be anything new. It would be such a small percent of what's in the possession of the Department of Justice.
Misty, you know, so many people are following the story on both sides of the aisle. Thank you for breaking it down. As always, my friend, Misty Marris. We appreciate you.
Thank you, Hannah. Always happy to be here.
Thank you.